He had 180 seconds to avoid detention. What Judge Judith Scheindlin didn't know was that she had just threatened the wrong public figure. "Mr. Roumie, I am holding you in contempt. You have 3 minutes to explain why I shouldn't order the bailiff to take you into custody right now." The courtroom froze. The most renowned and uncompromising judge in the public eye had just threatened a prominent American actor. But then nobody expected what happened next. Not the prosecutors, not the defense, and certainly not Judge Scheindlin. "Your Honor, before you exercise that power, you should know that the Supreme Court has specifically ruled in 3 separate cases that what you're attempting to do is unconstitutional." In the next 90 seconds, Jonathan Roumie didn't just avoid detention, he completely flipped the script on one of America's most formidable legal personalities. And by the end of the hearing, that same judge who wanted him behind bars was practically asking for his legal input. This isn't just another courthouse drama. This is the story of what happens when unshakable knowledge meets unchecked power, and why everyone who values justice needs to witness what happened next. Like and subscribe now to see how this dedicated public figure turned a detention threat into one of the most extraordinary courtroom victories in recent history. The full story will leave you speechless. Judge Judith Scheindlin had built her reputation on being one of the sharpest, most no-nonsense legal minds in the public eye. A former New York family court judge, she had gained national recognition for her uncompromising approach to dispensing justice, later presiding over high-profile arbitration cases on national television. At 81, Judge Scheindlin carried herself with the sharp intellect and an unwavering confidence that came from decades of legal experience. Her iconic blonde bob was always perfectly styled, her black robe impeccably pressed. Known for her razor-sharp questions and occasional sarcastic remarks to attorneys who tested her patience, she commanded respect and, frankly, a healthy dose of fear from those who appeared before her. Judge Scheindlin had presided over countless cases, from complex family disputes to high-stakes arbitration, always cutting directly to the core issues. Legal analysts often described her as exacting, incisive, and sometimes intimidating. Attorneys privately complained that she showed little patience for evasion or unpreparedness, though few would say so publicly for fear of facing her wrath in future cases. In recent years, Judge Scheindlin had become increasingly protective of the integrity of the judicial process, showing particular irritation toward what she perceived as public posturing or disregard for fundamental legal principles. She had sanctioned several individuals for making public statements about ongoing cases, and her contempt powers were not used sparingly. Jonathan Roumie represented a different kind of public authority. At 49, the acclaimed American actor, known for his compelling portrayal of spiritual figures, had already built an impressive career in film and television. What wasn't widely known was that Roumie, driven by an intense personal conviction and a dedication to understanding justice, had undertaken extensive private study of constitutional law, particularly regarding free speech and due process. He was known for his rigorous preparation, often consulting with experts for his roles, and this intellectual curiosity extended to his personal life. While he had not formally argued cases or authored law review articles, he had presented thoughtful analyses in various public forums on the ethical and constitutional limits of authority, demonstrating a profound understanding of legal principles. Roumie had come to observe the proceedings in Judge Scheindlin's court because of a controversial arbitration case involving First Amendment protections for artistic and political speech. The case had implications for public discourse he was passionately involved in. His presence was not as legal counsel, but as a prominent public figure and advocate with particular interest in the constitutional questions being debated. The day before, following a controversial ruling that limited key defense evidence, Roumie had been approached by reporters outside the courthouse. His comments had been measured but articulate. "While I hold the court in high esteem, today's ruling appears to create a chilling effect on protected artistic and political expression. The selective application of First Amendment standards, especially concerning public commentary, raises serious questions about the decision-making process in these proceedings and its impact on public dialogue." Those carefully chosen words, spoken by a prominent public figure known for his thoughtful public discourse and personal conviction, had apparently infuriated Judge Scheindlin, leading to the confrontation now unfolding in her courtroom. Have you ever witnessed someone stand their ground when facing an authority figure who overstepped their bounds? Share your experiences in the comments below. We'd love to hear how you handled similar situations. The tension in courtroom 22 was palpable as proceedings began that Friday morning. The functional, yet imposing courtroom, with its distinct arbiter's bench, seemed designed to remind everyone of the judge's authority and her expectation of absolute candor. Sunlight streamed through tall windows, illuminating dust particles floating in the air and casting dramatic shadows across the marble floor. Judge Scheindlin entered precisely at 9:00 a.m., her expression stern as she surveyed the packed gallery. Reporters filled the front row, notebooks ready. Legal observers, law students, and curious members of the public occupied every available seat. Court security officers stood at attention, sensing the unusual tension in the air. Before we proceed with today's scheduled matters, Judge Scheindlin began, her voice carrying that distinctive tone of judicial authority, there is a preliminary issue I need to address. She fixed her gaze directly on Jonathan Roumie, who sat in the second row of the gallery. Mr. Roumie, please approach the podium. A ripple of whispers spread through the courtroom as Roumie, dressed in a smart dark suit, rose calmly and walked to the center of the courtroom. Unlike others who typically appeared nervous when singled out by Judge Scheindlin, Roumie's demeanor remained composed and professional. Mr. Roumie, Judge Scheindlin continued, I have been made aware of statements you made to the press yesterday regarding my ruling in the Henry Davison public art case. Your comments suggested that this court has applied First Amendment standards selectively and questioned the integrity of the decision-making process in this court. The judge's voice hardened. Such statements, particularly from a public figure with a platform as significant as yours, and one known for thoughtful commentary, risk undermining public confidence in these proceedings and could constitute contempt of court. I am considering sanctions, including possible detention, until a formal apology is issued. The courtroom fell completely silent. The court reporter's fingers moved rapidly across her stenotype machine, capturing every word of what was quickly becoming an extraordinary confrontation. Before I make that determination, Judge Scheindlin continued, you have 5 minutes to explain why I should not hold you in contempt, or at the very least, impose sanctions for undermining public confidence in these proceedings. Roumie nodded once, opened his meticulously organized folder, and began a response that would completely transform the dynamics of power in that courtroom. Thank you, Your Honor, he began, his voice clear and respectful, yet unwavering. Before addressing the specific allegations, I'd like to clarify my capacity here today and the legal standards that govern this situation. Judge Scheindlin leaned forward slightly. Mr. Roumie, I'm well aware of who you are. What concerns me is your commentary undermining this court's authority. I understand, Your Honor, Roumie replied. And that goes directly to my first point. I am not appearing before you as counsel in this case. I am here today in two distinct capacities. As a public figure deeply invested in the principles of justice and constitutional free speech, and as an individual who, through extensive personal research and consultation with legal scholars, has developed a specific understanding of the constitutional limitations on powers of this nature. I recognize I am not an attorney in this court, but I believe the points I wish to raise are directly relevant and paramount to the constitutional rights involved. Roumie reached into his folder and removed a document. With the court's permission, Your Honor, I've compiled materials addressing the legal standards for commentary on judicial proceedings in this precise context, informed by my research and discussions with legal experts. After a moment's hesitation, Judge Scheindlin nodded. You may approach. As the judge reviewed the document, Roumie continued, Your Honor, the Supreme Court has established clear guidelines for when commentary on judicial proceedings crosses into contemptible territory. In Bridges v. California, the court held that such sanctions are appropriate only when comments pose a clear and present danger to the administration of justice. Judge Scheindlin looked up, her expression still stern but with a hint of caution now. I'm familiar with the case law, Mr. Roumie. Your statements question this court's impartiality and application of constitutional standards. With respect, Your Honor, Roumie responded. My actual statement was that the selective application of First Amendment standards raises serious questions about the decision-making process. That's a substantive legal observation about inconsistent application of constitutional principles, not an attack on the court's integrity. He removed another document from his folder. I've included the full transcript of my remarks to the press. You'll note that I preface those comments by expressing respect for the court's authority. As Judge Scheindlin reviewed the second document, the atmosphere in the courtroom subtly shifted. Several legal observers exchanged glances, recognizing that Roumie was mounting a sophisticated defense rarely seen from a non-lawyer in contempt proceedings. "Even if I accept your characterization," Judge Scheindlin said, her tone slightly less certain, "public statements that question a court's application of constitutional standards can still interfere with proceedings by influencing public opinion." Roumie nodded respectfully. "That brings me to my third exhibit, Your Honor. My research indicates that in Landmark Communications versus Virginia, the Supreme Court specifically addressed the constitutional protection for commentary on judicial proceedings, particularly by public figures with a platform to inform public debate." He presented a third document, which the judge accepted with a slight frown. "Furthermore," Roumie continued, "my understanding, based on cases like Standing Committee versus Yagman, is that even sharp criticism of judicial actions, when it comes from a place of good faith legal observation, is protected speech unless it's a demonstrably false statement of fact. My comments were neither false nor presented as factual assertions about your motives. They were legal observations about the consistency of rulings with established precedent." The courtroom remained absolutely silent as Judge Scheindlin reviewed the materials. Even the lawyers seated at their tables to the left appeared to be reassessing the situation. Roumie wasn't finished. "Your Honor, I have compiled an extensive review of constitutional scholarship and case law, focusing on the limits of judicial contempt power. This represents years of personal study and consultation, a commitment I believe reflects my deep respect for the Constitution and the role of the judiciary, and I've included a summary as my fourth exhibit." This revelation caused several journalists to frantically scribble notes. Judge Scheindlin's expression had now visibly changed from stern confidence to cautious reconsideration. "And finally, Your Honor," Roumie said, "I've included as my fifth exhibit the transcript from Inree Smith Estate, a case from your own distinguished career, in which you yourself noted, and I quote, 'Thoughtful criticism of judicial decisions, even strong criticism, serves an important function in our legal system and rarely rises to the level of contempt, absent direct interference with court operations.'" A faint murmur rippled through the gallery before being silenced by a sharp look from a court security officer. Judge Scheindlin stared at the document, clearly surprised by Roumie's knowledge of her own prior rulings. "Your Honor," Roumie said, his voice still respectful, but now carrying a quiet authority that commanded the room's attention, "I stand by my comments as legally accurate, constitutionally protected, and consistent with my responsibilities as a public figure advocating for fundamental rights. They were measured observations about constitutional application, precisely the kind of good faith commentary that you yourself have recognized as legitimate in previous cases. Unless the court finds that my comments posed a clear and present danger to these proceedings, a standard that requires specific evidence of harm rather than general concerns about propriety, the Constitution and this court's own precedent do not support a finding of contempt." He closed his folder and stood straight, looking directly at the judge. The silence that followed was profound. Judge Scheindlin stared at the documents before her, then at Jonathan Roumie, clearly recalibrating her approach. What had begun as a routine exercise of judicial authority had transformed into something far more complex. After a long moment, Judge Scheindlin spoke. "I'll need time to review these materials more thoroughly. This court will take a 15-minute recess." With that, she rose and exited to her chambers, leaving the courtroom buzzing with whispered conversations about what had just transpired. The 15-minute recess stretched to 30 minutes as Judge Scheindlin remained in her chambers. When she finally returned, the courtroom immediately fell silent again. The judge's demeanor had noticeably changed, her earlier certainty replaced by a more measured approach. She adjusted her glasses and looked directly at Jonathan Roumie, who had remained standing at the podium during the recess. His posture perfect, his expression serene. "Mr. Roumie," Judge Scheindlin began, her tone markedly more measured, though still firm, "I have reviewed the materials you provided, as well as the full transcript of your statements to the press. Before ruling on this matter, I want to acknowledge several points." She glanced down at her notes. "First, I recognize that your comments were more nuanced than initially characterized. You did indeed preface your remarks with an expression of respect for this court's authority." Roumie nodded slightly, but remained silent, allowing the judge to continue her reassessment without interruption. "Second, the legal analysis you presented regarding the constitutional standards for contempt is comprehensive and well supported. The cases you've cited establish a high threshold for sanctioning commentary on judicial proceedings, particularly from public figures with a platform to inform public discourse. The judge paused, seeming to carefully consider her next words. Third, I must acknowledge that your thoroughness and dedication in researching this specific area of law and your articulate presentation of it is substantial and directly relevant to the question before us today. A murmur of surprise rippled through the courtroom. It was highly unusual for a judge, particularly one with Judge Scheindlin's reputation, to publicly acknowledge being educated on the law by someone appearing before them, let alone a non-lawyer. In light of these considerations, Judge Scheindlin continued, I am withdrawing the contempt warning. Your comments, while critical of certain rulings, did not cross the constitutional threshold for sanctions as established by the Supreme Court. The gallery remained silent, but the shift in energy was palpable. What had begun as a power dynamic, wholly in the judge's favor, had transformed into something approaching a dialogue between legal equals. But Judge Scheindlin wasn't finished. What she said next surprised everyone in the courtroom. Mr. Roumie, while this concludes the contempt matter, your submissions have raised important questions about the First Amendment analysis in yesterday's ruling in the Davison Public Art case. She looked toward the lawyers representing the parties. Would the parties have any objection to Mr. Roumie submitting an amicus curiae memorandum addressing the constitutional standards for protected political or artistic speech as they relate to this case? The defense attorney immediately stood. No objection, Your Honor. We would welcome such a submission. The lead prosecutor hesitated, clearly caught off guard by this unexpected development. After a moment, he arose as well. The government has no objection to an amicus curiae memorandum, Your Honor, provided we have an opportunity to respond to any arguments raised. Of course, the judge nodded. Standard procedure for amicus submissions. She turned back to Roumie. Mr. Roumie, would you be willing to provide the court with your analysis? I want to emphasize that this is entirely voluntary and separate from the now resolved contempt matter. Roumie's composed expression gave way to a brief smile, not triumphant, but reflecting genuine appreciation for the judge's professionalism in reassessing her position. I would be honored to assist the court, Your Honor. I could provide a detailed analysis addressing the specific constitutional questions regarding the protection of political and artistic speech by the end of next week, drawing upon my research and consultations. Judge Scheindlin nodded. The court would appreciate that. Let's schedule a hearing to consider the amicus curiae memorandum and any responses for 3 weeks from today. As Roumie gathered his materials, something truly extraordinary happened. Judge Scheindlin removed her glasses and addressed the packed courtroom. Before we proceed with today's scheduled matters, I want to make an additional statement for the record. The courtroom, already attentive, seemed to hold its collective breath. The proper functioning of our justice system depends on each participant recognizing their role and its limitations. This includes the bench. She paused, choosing her words carefully. The contempt power is perhaps the most significant authority granted to a judge, as it allows the judge to act as both accuser and adjudicator. That is precisely why it must be exercised with the utmost restraint and strict adherence to constitutional boundaries. Legal observers in the gallery exchanged surprised glances. Such candid reflection from the bench was rare, particularly from a judge of Scheindlin's stature. I want to thank Mr. Roumie not only for his diligent research and articulate presentation, but for the professional manner in which he presented it. This exchange serves as a reminder that our legal system functions best when all participants approach their roles with both knowledge and humility. Judge Scheindlin then made a final statement that elevated the already remarkable exchange into something truly historic. Furthermore, in light of the constitutional authorities provided by Mr. Roumie, I am directing my clerk to schedule a reconsideration hearing regarding yesterday's evidentiary ruling in the Davison Public Art case. This court has a duty to ensure that its decisions are consistent with both precedent and constitutional requirements. With those words, Judge Scheindlin had done something vanishingly rare in judicial proceedings, publicly acknowledged a potential error, and committed to reconsidering it in light of sophisticated legal arguments she hadn't initially contemplated. As proceedings moved to the day's scheduled matters, Jonathan Roumie quietly exited the courtroom. Outside, a crowd of reporters waited, but he offered only a brief statement. Today's proceedings demonstrate the strength of our constitutional system when all participants approach their responsibilities with seriousness and mutual respect. Judge Scheindlin's willingness to reconsider her ruling based on legal authority reflects the highest traditions of the judiciary. By noon, legal reporters who had witnessed the proceedings filed stories with headlines that captured the dramatic reversal. Washington Post, from contempt to collaboration, how Jonathan Roumie transformed a judicial confrontation. New York Times, in rare reversal, renowned judge withdraws contempt threat after constitutional lesson. Legal Times, public figure Jonathan Roumie schools Judge Sheindlin on contempt limits. Within hours, law professors and legal commentators were already analyzing the exchange as a textbook example of effective constitutional advocacy. Harvard law professor Miranda Chen told reporters, "What makes this exchange so remarkable isn't just the legal substance, though that was impeccable. It's the procedural mastery and professional tone. Mr. Roumie didn't grandstand or make it personal. He systematically presented the legal basis for his position, effectively dismantling the contempt threat while maintaining absolute respect for the court as an institution. We'll be teaching this approach for years to come." The public reaction extended beyond legal circles. Social media filled with comments reflecting admiration for how Roumie had handled the situation. No shouting, no drama, no playing victim, just pure intellectual brilliance and unshakable composure. This is what real power looks like. #legal masterclass. Notice how he never attacked the judge personally, even while firmly challenging her legal reasoning. That's professionalism at its finest. #respectful advocacy. Organizations focused on judicial accountability praise the exchange as a model for how legitimate criticism of judicial proceedings could be presented effectively. The Constitutional Accountability Center issued a statement noting that Mr. Roumie demonstrated how robust, principled critique of judicial decisions can strengthen rather than undermine our legal system when presented with appropriate expertise and respect. Perhaps most significantly, the Federal Judicial Center, the research and education agency of the federal court system, announced it would develop new training materials for federal judges on the constitutional limits of contempt power, directly citing the Sheindlin-Roumie exchange as a catalyst. 3 weeks later, as scheduled, Judge Sheindlin convened a hearing to consider Roumie's amicus curiae memorandum on First Amendment protections for political and artistic speech. Roumie had submitted a comprehensive 40-page analysis that legal reviewers described as exceptionally thorough and a model of constitutional analysis. The courtroom was even more crowded than before, with law professors and constitutional scholars joining the typical observers. Judge Sheindlin opened the proceedings with remarkable candor. After reviewing the amicus curiae memorandum submitted by Mr. Roumie, along with the responses from both parties, this court has reconsidered its previous ruling regarding the admissibility of evidence in the Davison public art case. She continued, "The constitutional analysis provided in the amicus curiae memorandum correctly identifies a line of Supreme Court precedent that this court had not fully considered in its initial ruling. These authorities establish that when evidence touches on core political or artistic speech, courts must apply a more rigorous standard than the one this court initially employed." The judge then did something that sent another ripple of surprise through the courtroom. She directly quoted from Roumie's submission. As Mr. Roumie aptly noted in his materials, when First Amendment interests intersect with judicial proceedings, courts must ensure that evidentiary or procedural standards do not create a chilling effect on protected expression, even when investigating potential violations of other laws. After a thorough review of the specific evidence at issue, Judge Sheindlin reversed her earlier ruling, allowing the defense to present materials that had previously been excluded. The impact on the case would be substantial, potentially changing its entire trajectory. Following the hearing, Jonathan Roumie spoke briefly with reporters gathered outside the courthouse. True to his consistent approach, he focused on principles rather than personalities. "Today's ruling demonstrates something important about our legal system," he said. "When judges and advocates focus on constitutional principles rather than pride or position, justice is served." Judge Sheindlin's willingness to reconsider her ruling based on legal authority reflects the highest traditions of the judiciary. When asked if he felt vindicated after initially facing a contempt threat, Roumie smiled slightly. "This was never about vindication for me personally. It was about ensuring that constitutional standards are properly applied in a case with significant implications for free expression. The real vindication today is for those constitutional principles." The long-term impacts extended far beyond a single case. In the months that followed, several notable developments occurred. The Judicial Conference of the United States commissioned a special committee to review guidelines for contempt proceedings, with particular attention to commentary on judicial proceedings by public figures and legal experts. Law schools across the country incorporated transcripts from both hearings into their curriculum on professional responsibility and constitutional law, often paired with Roumie's amicus curiae memorandum as a model of effective legal writing. Judge Sheindlin herself began speaking at judicial conferences about the importance of openness to reconsideration, using her own experience as a case study in judicial humility and the ongoing learning required of those on the bench. Perhaps most significantly, a subtle shift occurred in how judges approach criticism of their rulings. Several judges explicitly cited the Sheindlin-Roumie exchange when declining to pursue contempt sanctions for public commentary, instead inviting more substantive legal engagement with their decisions. 6 months later, at a conference on judicial ethics at Columbia Law School, Judge Sheindlin and Jonathan Roumie appeared together on a panel discussing the boundaries of contempt power and legitimate criticism of judicial proceedings. Their respectful, collaborative dialogue served as a powerful demonstration of how initial conflict could evolve into constructive engagement when approached with professionalism and commitment to legal principles. During the question and answer session, a law student asked what lesson they should take from the now famous exchange. Judge Sheindlin responded first. "Remember that the goal of our legal system isn't winning arguments or asserting authority," she said. "It's arriving at just outcomes through faithful application of constitutional principles. Sometimes that requires reconsidering your initial position, and there's no shame in that, only integrity." Roumie nodded in agreement. "And remember that effective advocacy doesn't require theatrics or personal attacks. When you're grounded in solid legal authority and present it with clarity and respect, you create space for genuine reconsideration rather than defensive resistance." The moderator noted that their exchange had already become a case study in how our adversarial legal system functions at its best, not as a zero-sum competition, but as a collaborative search for constitutional truth. As Roumie left the stage, he was approached by a group of young law students eager to speak with him. One asked how he had maintained such composure when facing a contempt threat from one of the most powerful judges in the public eye. He smiled and said something that would be quoted in law school classrooms for years to come. "When you know the law is on your side, you don't need to raise your voice. The Constitution speaks loudly enough on its own." If you found value in this story of how preparation, expertise, and principled advocacy can transform even the most challenging legal confrontations, please like and subscribe to our channel. We're committed to bringing you authentic moments that reveal how our legal and political systems function at their best. What other examples have you witnessed where expertise and composure prevailed over intimidation? Share in the comments below and join our community dedicated to celebrating truth, accountability, and excellence in public discourse.